Good evening, everybody. My name is Christopher Kirchhoff, and I, alongside my co-chairs and the entire Environmental Studies Department, would like to welcome you to our second night of our Environment Across Boundaries Symposium. Tonight, we welcome some distinguished guests who will be discussing the effectiveness and possibilities of law and policy in addressing climate and environmental issues within the era of post-truth. On behalf of the entire Lewis and Clark College community, I would like to extend a very warm welcome to tonight's panelists. Ken Helm, a state representative from the 3rd District of Oregon. Kieran O'Donnell, the manager of Office of Compliance and Enforcement with the Oregon State Department of Environmental Quality. Courtney Johnson, an executive director and attorney with the Crag Law Center. Tom Buchele, a co-director of the Earthrise Law Center and law professor at the Lewis and Clark College of Law. Also joining them as tonight's moderator will be Kieran Russell, who also works with the Earthrise Law Center and Lewis and Clark Law School and is currently my 460 professor. Without further ado, I'd like to welcome Professor Russell to the podium to deliver a brief introduction.
Good evening, everyone. Thank you to our panelists for joining us tonight, and thank you to the symposium organizers for asking us to come. We're really excited to talk on this topic tonight. I'm going to start with an outline of what we're going to do tonight. So first, I'm going to give a brief explanation of what is meant by post-truth era, just to set the stage. Many of you may have already heard about it in prior parts of this symposium, but just to make sure we're all kind of thinking about the same thing. And then we will do a quick setting of the legal stage, and I will give an quick overview of some of the basics of the United States environmental laws, and then Professor Buchele will talk and give an overview about the ethical obligations of lawyers, which we feel is one of the big questions or issues in this post-truth era. Then I will introduce our panelists, give you a little more background as to why we were thinking they would be good for this discussion. We gave each of our panelists 5 questions to ponder before they came tonight. And then we will do our discussion. We're asking that we hold questions until the end, which we're hoping to have about an hour discussion. We have people online who hopefully will also be asking questions. We'll do a half an hour for questions, and then we will hear some concluding thoughts from the symposium's keynote speaker, which we are excited to have here tonight. So I wanted to start out by just doing what is meant by the post-truth era. And I think some would define it as a counterintuitive notion, and the source of abundant debate. Certainly when we were talking about this panel, there was we had a debate internally. And at the symposium, as I understand it, the idea was to build on the understanding that a post-truth era is an era not marked only by widespread untruths, but also by skepticism by some segments of the society regarding the possibility of truth. And that institutions that once held the implicit trust of the public, like governments or schools or scientific research and authorities, are increasingly cast in the light of suspicion. And individuals turn to alternative sources to help them interpret the world around them. And so you have the power to decide between narratives is no longer held in customary sources of authority or common understanding or sources of authority. And you see an increase in skepticism over science and politicization of science, which I will kind of get into in a few minutes, is very important when we are designing and implementing environmental laws. So tonight, and I guess previous panels have explored what it is to grapple with post-truth in a range of contexts, including politics, media, and environmental activism. And tonight we will explore how post-truth narratives impact the world of environmental law. So law or laws are defined as a system of rules that govern our behavior in society. And at its core, the law engages with truth in a way that arguably no other institution or authority does, and has long functioned as one of the principal guidelines for what is just and valid, leading many to assert that the law alone may be able to resist this erosion of our common truths by mistrust and the ambiguity of post-truth. So tonight, our speakers will address this key issue, drawing upon insights from various legal perspectives. We have very talented, smart lawyers on this panel, representing administrative agencies, which Kieran O'Donnell does, representing legislators, which Ken Helm does, and then litigators, not last but not least, which Courtney does, and then Tom, who is an environmental litigator in his own right, but also teaches ethics at the law school, is going to help present, in the era of post-truth, how do we deal with ethics, and what are the current ethical expectations of lawyers. So I want to do just a very basic framework. We have a whole law school dedicated to many classes on environmental law, and we have a whole course at the undergraduate campus talking about environmental law. But I think there are a couple of things to just set the stage for the discussion tonight, because in looking at this question, all of us as lawyers, I think maybe analyzed it differently than someone who wasn't a lawyer. So I think, as we all know, the main source of law in the United States is the United States Constitution, and it creates our framework of government, our basic framework, and the law that around our basic framework of government. And it establishes three branches, right? You've got the legislative branch, Congress, which establishes laws in a way that have to be consistent with the U.S. Constitution. You have our courts, which are charged with interpreting the law, both the Constitution and legislation. And they do this on a case-by-case basis. So courts are making decisions based on disputes between parties. There may be many litigants, on either side, or there may be just one or two. And so the court's job is to figure out what the facts are, and then apply the law to the facts and come up with a solution. And if there's a dispute over the facts in the context of a court, then either the judge, or if you have a jury trial, they decide what the facts are. And the people in the proceeding have to live with that, basically. There are ways to appeal that, but the court is the decision maker. And also, in some cases where the Constitution or the Congress don't specifically address something, the courts may do it on their own using equitable principles and create something called common law. And so one of our this is my favorite topic, which is water law. One of our most important and precious resources, was first, some of the earliest laws addressing how we would manage that resource came out of the courts in common law, grappling between people who are using water and having fights. So common law can have a real effect also on resource issues. Okay, so you got Congress, and you've got the courts, and then of course you've got the executive branch, the president, and they implement and enforce the law passed by the legislative branch and as interpreted by the courts. And federal law, of course, is the supreme law of the land, but where federal law doesn't directly address something, or even indirectly, then state governments and local governments can adopt laws that affect our environment. So backing up to the United States environmental federal environmental laws. In the US, most of our big laws, the Clean Water Act, the Clean Air Act, the Endangered Species Act, those laws are based on a model of setting national standards and policies and then giving the states authority to implement and enforce the law. And this is known as cooperative federalism. Many of our signature laws also set science and technology-based goals and standards that must be met to achieve environmental protection. And these are also known as command and control laws, and they usually involve carrots, such as federal funding to do science-based research, develop the science related to various issues, and then money to help pay for infrastructure improvements. And so I think basically Congress, in passing these big laws, recognize that environmental problems, the causes are complex and the solutions are complex. And Congress isn't a technical expert. So also another big feature of our environmental laws is that Congress said, hey, we're not the expert, and/or we can't agree on the exact standard that should be used, so we will create a federal agency staffed with experts and policy people to help carry out the purposes of the law. And they are supposed to set precise standards to meet legislative policies and then update those standards as new scientific information and technology comes forward. And importantly, administrative agencies have a huge effect on how our environmental laws and policies are implemented, but they are creatures of statute, and they only have the authority to act that Congress has given them, or if a state legislature creates an agency that state legislature has given them. And in challenges in court or litigation, administrative agency proceedings, in challenges to administrative decisions, basically, courts tend to give deference to the expert agency. And they may give deference in terms of the agency's finding of fact, as long as it's based on documentation, that the agency's decision is documented, and it's something called the record of its decision. There's documentation basing to help show how they're reaching those findings of fact. And then where the law is not clear, courts will defer to agencies' reasonable interpretations of statutes. So it gives agencies in general, both federal and state, a lot of say in how our environmental laws look and are enforced. And so I think, I guess what I want to point out here is that, Okay. What I want to point out here is that science has played and continues to play an important role in how we establish our federal and state laws and development of those laws and how we implement it. So with that, I wanted to introduce Professor Tom Buchele, and I want to do a really quick, just give you a little bit of background about him. He, as is already mentioned, he teaches the environmental ethics class at the law school, and he's co-director of Earthrise Law Center, co-directs the clinic. But he is also a senior litigator at the clinic, and he does land management and natural resource practice, including mining, oil and gas, and logging issues. And then prior to coming to Earthrise, he was the director of the Environmental Law Clinic at the University of Pittsburgh for 7 years, a staff attorney at the Environmental Law and Policy Center of the Midwest. He was partner for a Chicago law firm for several years, and he is a graduate of Illinois Wesleyan University and the University of Illinois College of Law. So with that.
Thank you, Karen. I'm going to take this off just because I cannot keep my glasses from fogging when I wear it. So when I hear the post-truth theme of this, I think one of the things courts do, and our courts are designed to do, and lawyers are actually part of the court system, is to find truth and to establish facts. And I think one of the good news things for tonight is the rules that we have, that lawyers have to follow and the courts have to follow, are mostly still working in that regard. And I know that these are not environmental cases, but tonight I'm going to talk briefly when I talk about the various rules. And the example I'm going to keep coming back to are the cases that we've recently seen about so-called election fraud and the big lie. I hope people noticed that all those cases failed. And that's because the system, at least for now, worked. And the system that worked there's actually a couple different pieces to it. First, I know people are sometimes surprised by this, lawyers actually have an ethical code that they have to follow. Lawyers have to be ethical. And there's very specific and fairly strict rules about that ethics. I spent a whole year teaching my second and third year law students those rules so that they can pass a test that they have to take before they can become lawyers about ethics. A lot of people don't know this. Judges have a very specific judicial code of ethics that they have to follow. This is something I am paying increasing attention to because the system, like I said, worked most recently, but the former president put a lot of new judges on the bench, and I know there are some of us that are watching to see what happens with them and hoping that they continue to follow the applicable rules. So what are those rules? One of the rules we hear about the most is actually not a rule of ethics. It's actually part of the federal rules of civil procedure. It's usually referred to most often as Rule 11. And it's the rule that lawyers get sanctioned for. And it's a rule that there's a couple different parts to it, but in terms of facts, it says when you sign something that you file in a court of law, the lawyer that signs it is certifying that he or she has an objective factual basis for the factual assertions that they make. I'm going to focus on the facts. They also have to have an objective basis for the law, but I think the facts are the most important here when we're talking about a post-truth era. And what's really, I think, good about Rule 11 is that it's an objective standard, which means it's, the reasonable person basis, and the fact that, a lawyer can't come in and put his or her head in the sand and say, well, I just didn't know, because it's evaluated objectively. And so the sanctions that we've seen recently issued against some of these lawyers trying to pursue the big lie about election fraud were primarily issued under Rule 11. And so that rule is there, and it's quite effective, although there's quite a difference between how some judges enforce it and things like that. I clerked for a federal judge. The judge I clerked for was a real believer in Rule 11. Some judges are less inclined to do sanctions, so that varies, but that's a very, very important tool. And then we have a code of ethics that applies to lawyers. Every state has their own code, but the American Bar Association has established what's called the Model Code, which sets out the basic rules. Some states tinker with those, but most of them basically follow the Model Code. And some of the things lawyers are required to do, they have to, just like Rule 11, they have to do meritorious claims and defenses. That's one of the rules. They have to do what's called candor towards the tribunal, towards the judge, which means no false statements. These seem like obvious rules, but it's good that we have them and they're written down. No false evidence. You have to actually be fair to your opposing party and opposing counsel. That's a rule. You can't falsify evidence or assist witnesses in falsifying evidence. At trial, you can't allude to evidence that's not admissible. This is important because related to the rules of evidence, the rules of ethics, we also have really specific rules about how evidence comes into court. And that was actually what really was the bar that was so successful in these election fraud cases was the rules of evidence that we have, which are, I think, closely related to the rules of ethics, have been developed over hundreds of years about how you introduce evidence into courts to establish facts. They're well established, lawyers are very familiar with them, except it seems these election lawyers that were challenging these election results, because when you listen to some of the things they were trying to introduce as evidence, it was frankly just appalling. And that's why some of these lawyers are being sanctioned. And it was great to see judges from all across the political spectrum applying these rules of evidence. They're all very well accepted. I often hear, I have students ask me about, appearing in front of a Republican judge or a Democratic judge, and we hear that, which I think people are usually referring to, what party the president was that appointed them. And until recently, I really didn't like to talk about that because, as I tell my students, I actually have won most of my cases in front of Republican judges. Judges, in my experience, most of them follow the law, and they follow the rules of evidence, and they follow the rules of ethics. And if I've got a good factual and legal basis for my claim, I've been able to win in front of Republican judges just as much as Democratic judges, to the extent that you can put those labels on judges. I hope that continues to be the case, although I have seen a couple of the judges appointed by the former president, most recent former president, and I have concerns about some of their conduct. So I think we need to watch that. But back to the ethical rules. There's a basic ethical rule that says while representing a client, you can't make a false statement to any third party. So lying and making up evidence and things like that is clearly unethical. So let's talk about judges and the basic rules for judges. Not surprising, the very first rule for judges is they have to comply with the law. Again, maybe we shouldn't even have to have that written down, but we do. I think the most important one is the next one. This is Rule 1.2, which says that judges are supposed to act in a manner which they appear independent, integrity, and impartial, and have no appearance of impropriety. They can't do impropriety, but also no appearance of impropriety. And what that means is the judge cannot walk up to the line. The judge has to stay way behind the line as far as what the ethical rules are. And I think that's really critical for judges. Judges are supposed to uphold the law fairly and impartially. They're not supposed to permit politics to influence their decisions or to allow anyone else to suggest that they can influence their decisions. I think that's an important rule. There's actually a rule that says judges are supposed to be patient, dignified, and courteous. That's actually one I saw a judge appointed by the recent ex-president violate, and that concerned me. Judges aren't supposed to make statements about impending cases or cases that are actually in front of them. Judges, and I think this is important, are not supposed to receive or consider evidence that didn't come in through the actual court process, evidence outside the record. I think that's important. And then finally, judges are supposed to disqualify themselves when their impartiality could be questioned or where there's an appearance of impropriety. So those are the basic rules about ethics. And like I said, they've worked so far, and they worked in the election fraud cases. I was really glad to see that. But I think the one part of the system that has not worked, and I'm really concerned about that, is the lawyers that did this, they didn't win their cases, but way too many of them still have a law license. And that really bothers me. Rudolph Giuliani had his suspended finally after like 4 years of lying, and a couple of the lawyers in the Michigan case have been sanctioned and are now being investigated. But the vast majority of these lawyers that did what I think are plainly unethical things, and in my opinion should have had their license suspended almost immediately, are still practicing law. And that part of the system has not worked so well. So I hope that the various bar organizations in each state has are responsible for that, and I hope that they're starting to look at that. And I think we need to have a better way to respond more quickly to obvious unethical behavior. I mean, it didn't stop the courts from reaching the right result in those cases, but it should concern all of us that those lawyers are still out there practicing law. I think that's enough.
Thank you, Tom. So we'll start on the questions portion of the discussion tonight. I wanted to do a little more introduction of our three remaining panelists. Oregon Representative Ken Helm, he was in private practice before being elected to the Oregon Legislature in 2014, had a robust land use law practice. He is chair of my favorite committee, the House Committee on Water. He is member on House Committees on Agriculture and Land Use, Energy and Natural Resources, and the Judiciary. He is also a member of Oregon's Global Warming Commission and an active participant in the legislature's Environmental Caucus, Wildlife Caucus, and Sportsman Caucus. He has a BA in History and Political Science from Willamette University and a Juris Doctorate from Willamette University College of Law. And then next to him is Courtney Johnson, Executive Director and Staff Attorney at Crag Law Center. And she has her JD from the Lewis and Clark Law School. And she has done some amazing work while she was at Crag, including leading local land use challenges to a 12-year fight to stop the proposed Joden Cove Pacific Connector gas pipeline and export terminal in Oregon's Coos Bay. She represented two young Oregonians in a climate justice or public trust case fighting to hold the state accountable for addressing the climate crisis. She is also representing the Nez Perce tribe on the cleanup and restoration of the Portland Harbor Superfund site, and she's a published author on topics of climate change adaptation and marine spatial planning. And then next to me is another august member, former law student at Lewis and Clark Law School, Kieran O'Donnell. Out of law school, he worked for several years, a year and a half, in his own private practice law firm, which he co-founded, before joining the Oregon Department of Environmental Quality, which is the critical environmental agency in Oregon. And he started as an environmental law specialist in 2013, and then since 2018, he's been manager of Oregon's DEQ, Office of Enforcement and Compliance, and has been involved in some very big cases with big fines against major polluters in Oregon. So he's done a lot to ensure Oregonians have a healthier and cleaner environment. So with that, I will read the first question. And the first three questions, each panelist, Tom may or may not respond to, but each panelist will respond to. On this first question, I'm going to ask Representative Helm to go first, and then Kieran O'Donnell to go second, and then Courtney to go third. So the first question is, discuss the role of science in your area of environmental law or policy.
Make sure this is working. There it goes. Okay. That's always the hardest part of speaking public. Nice to be with you tonight. I thought this question is best answered by talking a little bit, and you should never give a politician an opportunity to talk without telling him or her how much time they have. A couple minutes? Okay. I don't want to steal time for other folks. So I thought I would tell you a little bit with relation to this question about the legislature's recent efforts to address climate disruption. There have been proposals over the last decade and a half about ways that we should approach addressing climate change in the state. Those efforts really ramped up and took on a new meaning in 2017 or so, and we really marched toward a possible solution in 2019. The good news in terms of the new world that we work in terms of fact-based decision-making, is that on the climate science side of that issue, it's not really very arguable anymore that the science is flawed. And when I entered the legislature in 2015, there were a couple of members of the Senate, I'm in the House, so we tend to be younger and smarter, and they tend to be older and, you know. There were still a couple folks that we would have called climate change deniers over in the Senate. That was the bad news then. The good news now is nobody talks that way anymore. It is simply not a rationally legitimate way to talk. There are other issues that are debated, but the fact that we are escalating in danger toward an environment that is going to cause humans and every other species on Earth great damage is not really, in the Oregon legislature, arguable anymore. We also have done a smart thing over the years in Oregon in establishing at the Oregon State University a climate information center, where we get objective scientific information that looks forward to potential impacts in the state that climate change may be bringing. That information is peer-reviewed, rigorously responded to by now an international community of climate scientists. And that's available to Oregon legislators at any time. And we've had multiple committee meetings in which we've heard from the Institute. That's all really good news. The bad news is the other side of the argument. It's if we try to make changes in the way we live and our economy to reduce greenhouse gases from the way we live and the way we work, what will the impacts be? That science is not really well developed. It happens to be more economic than environmental, and brain psychology and ordinary psychology is telling us these days that it's hard to correct misperceptions once falsities have been stated. So in 2017, 18, and 19, when we're really charging hard to try to do something legislatively, the opponents of making the changes only had to say it's going to be economically devastating over and over and over. And despite the fact that we had economic analysis telling the legislature how beneficial moving toward, for example, renewable electricity sources, that didn't really matter. The bullhorns came out and the impact on the economy was going to be devastating without many facts behind it. And I think that is probably one of the ripple effects of the damage that the 2016 presidential campaign brought to us and Trump's non-truth era dynamics, is that it's no longer embarrassing to be disingenuous or lie in public. And that's how it's rippled over into politics, in that you can combat facts with simply restating your position over and over and over, and in some instances it worked. So I won't go into how the fallout occurred. We did not obtain the legislation that I worked so hard on in 2019. The governor was able to get to it in a different way, which is not as good as what we had planned, I will be frank. But we were able to take some action in the state. But I do think that that condition still confronts us in the public forum.
Well, first I want to say thank you for the opportunity to speak here, Kieran and Janice and Lewis and Clark College. It's great to be up here again. and to share the stage with such esteemed panelists, Representative Helm and Tom and Courtney. I have a confession to make. I am a bureaucrat, and so I have to provide a disclaimer that tonight what I'm going to say are my opinions and not necessarily the positions of the state. So I work for DEQ, and the role of science at DEQ is absolutely essential and foundational to our work. The agency's mission is to protect human health and the environment. That's why it exists. We have a lab in Hillsborough. It's actually probably very close to Representative Helm's district, if not in the district. I'm not sure exactly. But it employs about 80 people or so, chemists, other scientists. The lab processes 10,000 samples a year of air samples, water samples, suspect material, maybe asbestos or hazardous waste. So there's a lot of monitoring of our environment that DEQ does. In the air quality section, for example, we have air toxics monitors throughout the state. And those monitors and the data that they gather help feed and inform the work of the state's air toxics program, the Cleaner Air Oregon program, which is another one of Governor Brown's greatest, I think, achievements, environmental achievements. We have a more vast network of PM monitors that support the air quality index. If any of you happen to download the Oregon Air app recently because of the smoke issues that we've all been experiencing, you were looking at DEQ data. The lab is most proud, well, I don't know about most proud, but the lab is also proud of this next thing that I'm going to mention, and that is it invented its own little box PM monitor that's super low cost and accurate and can be deployed almost anywhere very quickly. It's called the Sensor, and OR is capitalized. So, that's on the air side, and similarly on the water side, we've got 160 ambient water quality samples out in different water bodies throughout the state that are capturing data that then inform either increasing or declining trends of water quality. We put out the integrated report every couple years, and this is a really important analysis that's done. It's actually done pursuant to the Clean Water Act, and the agency looks at water bodies' ability to support all beneficial uses of that water body and whether or not a total maximum daily load is needed. So again, those are all kind of terms of art from the Clean Water Act. And then just yesterday, we announced that we're partnering with the Oregon Health Authority to monitor, I think it's about 150 public drinking water sources that are near suspected or known PFAS sites. And so these are also small water systems, so supporting 10,000 people or less. And so this is all very important monitoring that goes on, that the agency does to determine what is in our air and in our water. But I think more specifically to my work, as Kieran mentioned, I work in the enforcement office. So I have a staff of 8 people, and we are responsible for drafting all of the civil penalty orders for all of the violations throughout the state for the federally delegated programs, Clean Air Act, Clean Water Act, RCRA, which is the Resource Conservation Recovery Act. Think of it as the land one. And also the state programs too. And those administrative orders carry civil penalties. They may carry specific corrective actions. And when we issue a civil penalty, the Constitution provides due process, right? And we have to afford a contested case hearing. And in those contested case hearings, we rely on science and data and monitoring to prove facts. So those are all of the reasons that science is, again, absolutely foundational to our work. But I also just want to say, as an employee of the department, there is really a culture among the employees that we are a science agency, that we have a mission to protect public health, and good science should direct the implementation of that mission. it's an agency staffed with hydrologists, chemists, I mentioned, a couple lawyers, unfortunately, I'm one of them. But I find that, and I know others do too, that is one of the more rewarding things about working for DEQ, is that is our mission, and that science is essential and foundational to our work. I'll pass it on to, is it Courtney or?
Thank you. It's great to be here in person, as everyone already said. So as Kieran described, I am a litigator. We sue people. We mostly sue the government, so Kieran and I are still friends, but there's kind of two main types of cases that I would say public interest environmental lawyers do. One is kind of a backstop to what DEQ does, which is citizen suits. People, community members can step into the shoes almost of an agency like DEQ and sue a polluter for violating the Clean Water Act or the Clean Air Act. And so in that instance, it's very similar to everything that Kieran just described. Those statutes are based in science. They are science-based regulations. To prove the violation, you have to look to the data. Ironically, we're often looking at the violator's own data because the law requires that you monitor and report. But in that instance, we're basically in step or in parallel with what DEQ does and those regulators are doing. Another key example is suing to challenge a government agency decision to allow some action, say, on public lands. So in that instance, we are still looking at science. But I would say that there's also this piece that as a litigator, you're looking at the science and the facts in conjunction with the law. And so logic and reason is a really big part of the equation. So in the case of challenging, say, the Forest Service deciding to allow logging on a forest, we had a case that was in the Tongass National Forest in Alaska. There's a serious concern about wolf populations that rely on deer, and deer in turn rely on big old growth trees, so that in the winter, the snows, the old growth trees keep the snows from hitting the ground, so there's food for the deer, and then the deer are food for the wolves. So there's this multi-layered analysis that goes into how many big trees do you need to support a wolf population. And so there's multiple steps in there that are not just data, but the interpretation of data. And there are pieces that are agency regulation about how that interpretation is supposed to occur. And so we often find ourselves digging in, and I would say a lot of our partners and clients have always had a healthy skepticism of government science. Digging in to look at the science and the data, but also to cross-check what that method was that was applied to the data. And I think that comes out in a lot of different other places that we could talk about. In Portland Harbor, for example, which is a place where the Nez Perce tribe works as a partner with the government agencies in trying to get the river cleaned up and in trying to get restoration projects in place. Right now, that's under CERCLA, or the Superfund law, which is a polluter pays law. So the polluters, or the potentially responsible parties, are responsible for going and collecting some data to see, okay, where are all the contaminants and how are we going to get them cleaned up? And there are constantly these battles between the PRPs, the polluters, or the potentially responsible parties, and the regulators, EPA and DEQ, about not only how to collect that data, but what those data mean. And that's the part where the getting agreement on how to collect the data is one thing, but getting agreement on what those data mean is a whole nother piece. And so I think there are a lot of places where we see science is bound up in all of this, but it's not quite as pure as just what does the science say. It's what does the science say in the context of the law. And when agencies or polluters are interpreting that, are they doing it based in a rational way, or is it arbitrary? We find ourselves often saying that agency decision was arbitrary and capricious, or was it rationally based, those types of things. And the other piece that I would just add is there are a couple other places where we see science showing up. Like, for example, in the Endangered Species Act, there are requirements to use the best available science. And that in itself is an acknowledgement that the science may change and evolve over time. And so it's another place where you're finding this, this ultimate truth, like what is truth, is maybe not as easy to place all the time. But this question of having that skepticism of what a government agency is saying is, what are enough big trees to support a wolf population? From my perspective, we've always had that little bit of healthy skepticism about that. But our skepticism is grounded in the science and is grounded in facts. It's not just grounded in emotion or opinion. And so we definitely see science as a grounding piece of environmental litigation, showing up in a whole lot of different ways across a whole series of statutes that we might be enforcing, or even the common law, as Kieran is mentioning, in places like water law and things like that.
Thank you. Okay, Tom, did you want to say anything? No. Okay. The second question is, and give you each about 2 minutes. Can you hear me over there? 2 minutes. Because this is one of our shorter questions, how is your area of practice affected by the increasing public distrust of scientific experts? And we're going to have Courtney go first, and then Ken, and then Kieran.
Okay, I can be quick because I think that piece about already having that healthy skepticism, I think, still plays in. But just coming back to a couple of things that Kieran said in the opening comments, and Tom too, that courts are trying to place themselves above the political and public opinion fray. They are trying to, and by rule, are applying the facts and the law. And so I would say that we don't see that piece, this kind of post-truth element, coming into play in our litigation, at least not yet. As Tom is saying, we may see that change. But the place that we do see some frustration is courts or juries are, to decide the facts. But in those cases where we're challenging an agency action, there is this deference to the agency. And so that's maybe one place where courts are less willing to dig into what the facts really are and are more willing to maybe lean on either a gut check or that sounds right to me from the agency. So we do see that play out. The other thing is we've always had some cases that just become a battle of the experts. So you have one expert saying one thing and one expert saying another thing, and then the courts have to decide where they land. I don't know yet how post-truth is going to play out in that ability to, as long as, to Tom's point, as long as those evidentiary rules are still playing out, in theory, you should still be able to undermine the expert that is not based in fact or in data. And the last thing I would say is just that this discussion reminds me of, it reminds me of the tobacco litigation, and it reminds me that this isn't really a new concept. I mean, for so many years, some scientists were hiding the truth about how tobacco smoke affected health, and then that carried out to other chemicals, and then that carried out to global warming and climate change. And so this kind of pattern of either hiding the truth, or maybe we didn't call it post-truth at that time, is certainly not new. And then by the time you finally get to being able to bring it to light and have accountability through the courts or otherwise, then I think we've kind of seen this pattern over and over in a lot of ways. So I just wanted to raise that as well. Who's next, Kieran?
Might be me. In the legislative sphere, one thing that should give you hope is when laws are passed, they have to make sense. They have to work. There's an existing framework in which they fit. Almost every law has pre-existing law that it has to fit with. So at the legislature, we have nonpartisan help to make sure that happens. So and that extends to our Office of Legislative Counsel, which are our lawyers that make everything, some of our crazy ideas work, to our legislative research staff that help us in the committees. So we have some checks internally that make sure that laws that are going to pass and be voted through our chambers will work to some level. So post-truth in that atmosphere is blunted. So there is a backstop to that. And I forgot what else I was going to say, so I'm going to save time and give it to somebody else.
Yeah, thanks. I think I don't have a whole lot to add. I think a lot of what Courtney said I would agree with. The civil penalty orders go to a contested case hearing, which is not before a judge, it's before an administrative law judge. So we're not in court exactly. But the contested case hearing is very trial-like. It can be described as litigation light, maybe. And similarly, the ALJs that I've worked with, have not demonstrated any kind of aversion to science or scientific experts or anything like that. So that is all good news. As I think Representative Helm mentioned earlier on, maybe the work of the agency is indirectly impacted by post-truth and by claims that science is not real or whatever in the political legislative realm. But again, that's not something that I see in my day-to-day work in the enforcement realm.
Tom, you have, okay. Okay, the next question. In recent years, there's been attempts to change how power is shared between federal and state governments when implementing federal environmental laws and to decrease the federal government's role in funding and conducting scientific research. And this push has been fueled in part by an effort to diminish the role of science in environmental decision-making, and even potentially politicize science. What are your thoughts on the role and the future of this historic cooperative federalism in our post-truth era and the role of science? And Kieran's going to go first.
Yeah, thanks, Karen, and thanks for your opening remarks that described what cooperative federalism is. My hope is that we can reinvest in the public sector and in our federal agencies, because I am a firm believer that the cooperative federalism model can work really well. I work in it every day. On a quarterly basis, for example, I have meetings with Region 10, EPA Region 10 counterparts in Seattle, and we talk about the most important violations under each of the three big federally delegated programs. Again, Clean Water Act, Clean Air Act, and RCRA. And those conversations are, there is a federal oversight tone. It's, what kind of progress are you making on these? But there's also a very much of a collaborative tone, like what kind of assistance, what kind of technical assistance might you need? What kind of expertise might you need, state, to better understand these high priority violations, for example, under the Clean Air Act? And, EPA is great for that, right? They are a national regulator. If we have in our state maybe 3 or 4 sources that might be subject to some requirements, EPA might have a history of working with 50 or 60 of them. So I really see cooperative federalism as a good model that can work very well. But in the enforcement context, there has to be a credible threat that EPA can come in and be the bad guy and issue a harsher civil penalty, right? Civil penalty liability is typically a little bit higher under the federal penalty authorities. And that credible threat is really important because it actually makes my job easier too as a state enforcement manager if there is a perception that a facility should come to the terms that DEQ brings to the table, whether it's a penalty amount, whether it's certain corrective actions, if again there's a threat that not working with the state might result in federal enforcement, which is going to be more costly, and you're going to have to deal with a U.S. attorney, and they're not going to be nearly as nice as the state might be. So, you know, as a model, I like cooperative federalism. There has to be that gorilla in the room, which is the term that Bill Ruckelshaus, the first EPA administrator, coined for this type of relationship that the state and federal government might have in the enforcement context. And unfortunately, you know, there are people that track EPA's enforcement actions, but they've generally gone down over the last 10 years or so. The Biden administration just this last year has been doing some interesting things as far as invoking kind of old statutes, but ones that haven't been used that frequently. But not only that, EPA's FTE have gone down, excuse me, that's one of those bureaucrat terms. It basically just means positions, by about 1,000 the last 10 years or so. So that weakening of the federal agency doesn't really help under a cooperative federalism model. If we're going to have a future and continue that model, we're gonna need to invest in our public sector and in our public sector resources. So that's what I have to say about that.
Yeah, I don't have as many clear thoughts on this question, the future of cooperative federalism, but I do agree with what Kieran's saying, especially when you think about talk about bureaucracy. You know, we have the state bureaucracy, but the federal level bureaucracy. The biggest example I can think of is working on the Jordan Cove Pacific Connector project, which was a natural gas interstate pipeline. And under the Natural Gas Act, that means that is exclusively under federal jurisdiction. So the Federal Energy Regulatory Commission has the say-so about whether that project can happen or not. But there are a couple of carve-outs in there for state-level review. One is under the Clean Water Act, and another is under the Coastal Zone Management Act. And that pipeline was going to cross more than 230 waterways at more than 400 actual locations. And even the state didn't have enough information to get a handle on really what the impacts could be to water quality from that project. So let alone, you know, a DC-based entity working at a federal level to be able to actually evaluate what the Clean Water Act impacts would be of a project like that. And so that was a place where the idea of the prior administration tried to strip that Clean Water Act Section 401 authority away from states, tried to limit it and say, you only have a certain amount of time to address this issue or else the state has waived it. And it was really interesting because our partners had been working, you know, tracking what the impacts would be of this pipeline on water quality, trying to figure out from the state whether the state DEQ had enough information to be able to evaluate this. Again, back to the actual data and the science about what the impacts would actually be. And really it seemed to be a game mostly of just obfuscation. Like it was just, we're not gonna give you the data, we don't know what the impacts will be, and we're not gonna share it with the state, but you should approve this anyway. And so that was a really interesting place where I think really it was so important that the state had that authority to do that review. And even at that level, the state was being asked to do this enormous task of trying to figure out what the impacts of this huge project would be across all these waterways. So in terms of that, having both the federal level regulator and having the state level, I think it's really important that we have both. And I'm hoping that under this post-truth era that we're not going to see a further eroding of that partnership.
On this issue, two things come to mind. One is remember that from a constitutional basis, powers that the federal government doesn't take explicitly or preempt are left to the states, 10th Amendment. So there are parts of much of how we manage our environment that are largely under state control. We get to decide the way we want to do things. So many areas that you would consider to be environmental laws or conservation laws. The state does control. The other issue there is, even with cooperative federalism, the states need to minimally comply with federal statutes. In most cases, I'm not sure if I'd go so far as saying all, I'm not sure, but in most cases, the states can go beyond the regulatory stringency of the federal statutes if they so desire. And so for an example of what Oregon did in this area, the Trump administration threatened to roll back made promises to roll back all sorts of environmental laws early on. It turned out that they really weren't competent to understand how to do that, and so a lot of that didn't occur. But one of the reactions that the legislature and the governor had to that was to say, if you roll back those environmental laws, we're not going to go along. We've already adopted laws that are compliant with our view of what the Clean Water Act requires. They are compliant with the Act as we see it now. They're pretty good. And if you roll back the standards, we're not rolling back with you. And we passed a bill, and my memory is it's 2550, and I think we did that in 2017. And we basically said that. And the governor signed that into law. And that has been the policy of the state since. So you do have that backstop as the state when the rules start to change at the federal level. Doesn't work in the opposite direction, I would suggest. If the feds increase the stringency of some of those environmental standards and say, states, you have to meet these minimums, we will have to go along. But you can keep yourself from backsliding as a state if you want to.
Thank you. Tom, do you have, okay. Question number 4, what are your thoughts on the future of administering environmental laws and policies in the United States, especially given the erosion in the public faith in science in the post-truth era? Is the use of agencies with scientific and technological expertise to develop and implement and enforce environmental laws still in our future? And there has been, some articles written about the rise of the administrative state, and agencies don't have elected representatives running them. And so there has been in the past some push to eliminate or greatly limit our use of agencies. So if you all could just weigh in as you would like.
At risk of going into a really arcane area of the law, the rules of evidence, there is one that it's sort of related to ethics and the rules of evidence, and but also it's been in the news recently too. So I think it's relevant. Generally our courts and our legal system emphasizes getting all the evidence out, all the reliable evidence to establish truth and facts. But there are a few exceptions to that our courts have recognized for a very long time. For example, most of you have probably heard of attorney-client privilege. And that rule says that the communications between an attorney and her client cannot be discovered. You can't make an attorney testify about those communications. And we do that even though that does actually interfere with finding truth and facts sometimes. And it's because we have decided, our system has decided, that protecting those communications is more important. So there are a few exceptions to truth and fact finding. Recently, another of these related exceptions is something that agencies can use, and it's called the deliberative process privilege. And it's something that's, again, it's been around for a while, but agencies, especially at the federal level, have been increasingly arguing, and arguing successfully, that their internal deliberations shouldn't be exposed to the public, or courts should not be able to look at these internal deliberations when you're looking at their decisions and reviewing their decisions. All you should look at are their public explanations for their decisions. And this causes me a lot of concerns about the increasing acceptance by the courts of this much, much broader deliberative process sort of privilege. And there's, again, really good examples of this recently. Another privilege that gets asserted, and we've seen this in the news, is executive privilege. That one is actually less well established, especially the breadth that we're seeing of it now, and I'm hoping that's not going to go anywhere. But the deliberative process privilege was really key in a case that made it up to the Supreme Court just a couple years ago. And it was a case, it's not an environmental case, but I think it's still important because it's the same area of the law, administrative law. And it was a challenge to the Secretary of Commerce's decision for the census to ask questions about citizenship. And the Secretary of Commerce, when he made that decision, gave an explanation that on its face really didn't seem to make much sense. And the courts decided that they were actually going to look beyond that explanation. And so they went into some of the deliberative documents and looked at it. And sure enough, in the internal agency deliberations, they clearly were giving much different explanations for the citizenship question, improper explanations. And the courts allowed that to happen. But increasingly, that's not happening, and more courts are accepting the argument that we shouldn't look at these deliberative internal documents. And I'm really concerned in the environmental sphere that's going to start to affect court decisions. In the past, we have, because we've been able to look at some internal agency documents, we've been able to show, especially in the ESA area, Endangered Species Act area, agencies are only supposed to look at science when they make their decisions about endangered species, especially decisions like listing, whether or not a species is going to be listed. But it wasn't that long ago that we were able to show, looking at internal documents, that agencies were looking at things other than science. And we're looking at impacts to farmers and ranchers and economics, and we were able to throw those decisions out because of this. And so I am concerned about the increased use of deliberative process to keep us from looking at what agencies are doing.
Go ahead, I'll go last.
Yeah, I think that's a really good point. And one of the things that comes to mind for me is kind of related, which is I think one of the bigger risks is the brain drain from those agencies. So the good people that work with Kieran and DEQ, the people that work at EPA who are scientists, when their work is being undermined by this post-truth approach, I think we saw a lot of people leaving positions. And that, to me, is kind of related to Tom's point, which is the people that I interact with at DEQ and EPA on Portland Harbor, for example, are all really trying to, are really proud of the science that they do and really holding themselves and their agency to a high standard. And I saw a lot of fatigue in those folks during the last administration, where there was this constant feeling of, is our work about to be overturned? Is someone who was politically appointed going to tell us that we have to do something else now? Especially on something like Portland Harbor, which some of you may know is 20 years into a process and still hasn't started cleaning up. So there's years and years and years of science already into this. So I think that that's a big concern for me, is more, not so much the law itself changing, but the people. It takes the people in the agencies and people in NGOs and nonprofits to actually help enforce those laws. And I think that's a big concern that I have, is what the effect is on folks like that. And then the second piece that comes to mind is maybe something that was kind of related to the keynote, which is around the messaging of science and facts. And one of the things that one of my colleagues and I talk a lot about is just how, say, the forestry industry, the logging industry, is very good at messaging how good for the forest it is to cut down trees and replant them as tree plantations, and how positive overall that impact is. And the environmental community is not as good at messaging what those impacts really are, not as good at having this clear, to Ken's point about once you say it, it's out there, and it's harder to pull that back, that untruth back. The environmental community and And in some cases, I think scientists are not as good at messaging and communicating in a way that builds that public support. And so I think that's related to the environmental laws to me, because we need public support for these laws. We need public support for them to be in place and for them to be enforced. And so there's a piece that concerns me a little bit about this post-truth era and the kind of propaganda aspect of that, and how the environmental community in some ways can do better in that art of communicating why these things are so important, what these impacts really are, and what it means to protect and preserve our environment for this and future generations.
Yeah, thanks. So this question obviously presents a bit of an existential crisis for me. If the future is of no more administrative agencies, I'm going to have to be looking to the Lewis and Clark career development folks to see if I can maybe get a job somewhere else. Yeah, I hope that's not the future. Courtney, you mentioned the brain drain. I think what is absolutely needed is, and I'm not trying to pander to the audience here, but critical thinkers entering the public sector, people motivated by an agency mission. That is what we need. We need all of us, or people entering the workforce, to consider public service as an avenue for them. It wasn't something that I thought I was going to do. I never thought I would work for DEQ when I was in college or when I was in law school. It kind of happened almost accidentally. And I've loved it. So I really do hope there is a future of agencies still enforcing the law. And I guess my question would be, if the agencies don't enforce the law, then what does, or who does? The rule of law enforcement is so darn important. There may be lots of firms out there, and I know there are many firms out there that on their own take measures to, eliminate the externalities when needed, right? They may say, you know what, we've got a stormwater discharge problem. We need to hire a consultant. We need to put in some pollution controls, and we need to get our pollutant concentrations below the benchmarks in our permit. And that's great. But some folks don't do that. And if we don't enforce against the unscrupulous firms, then the good ones are at a competitive disadvantage, right? So again, really hoping that there is a future for me at DEQ.
Quickly, I'll add from a slightly different angle. About 50% of the land area in Oregon is managed by federal agencies under these federal laws that we're talking about. There are perennial calls in many states that have federal lands, and this is dominant in the West, this is more true in the West than the rest of the country, to cede those federal lands to the states on the idea that the locals could better manage them. And that is a terrible idea. It's a terrible idea just from the mere fact that we don't have the money or staff to manage those lands adequately, let alone the fact that they're being managed okay now under the federal agencies that are in charge. So to the extent that we need those federal agencies to operate well, operate with science-based and data-based systems in mind, is really important for us as states to reinforce, because we just simply do not have the capacity to do it well ourselves, and we need that federal help.
Great, thank you all. Okay, we have one more question, and then we will turn to questions from the audience. So climate change is one of the most important post-truth topics out there, and there is widespread disillusionment with the way authority figures have handled the issue. How is climate change being addressed or not in your area of law practice today? What changes in the law and policy are needed to address climate change, and what are the opportunities and challenges to achieve these changes in our post-truth era? Who wants to go first?
I can. Oh, go ahead, Tom.
I guess some of the changes, I'll focus on that I'd like to see. I think there could be some real simple rule changes for agencies. One, I would like to see a rule that says agencies can no longer argue that what they're doing is so small that it really affect climate change and they shouldn't have to think about climate change. When they look at that, we continually see that argument from agencies. I do timber sales, and we always hear the agencies say, well, you know, it's just a few thousand acres. In the broader scheme of things, it doesn't matter. But of course it matters. I mean, these things all add up. That's the whole point. And I'd like to see just a basic rule that says they need to stop that. And they need to consider climate change on all aspects of things. I guess the other change I would like to see, and this has to do, I actually did a highway case. I don't always do logging cases here in Portland. And I would like to see a rule that requires that agencies, if there's a history of something not working, I would like to see a rule that says if they're going to argue that this time it will work, they actually have to have evidence. And for highways, and this is going on right now in Portland, I just get so frustrated by it. There is now decades of documentation that when you expand highways, it induces more traffic. It does not solve congestion. This is not a disputable thing, in my opinion. But nevertheless, the Oregon Department of Transportation continues to argue that this time, when they expand the Rose Quarter or they build a 12-lane bridge over the Columbia River, it actually won't induce traffic this time. I think they shouldn't be able to do that unless they have evidence. And I'll get off my soapbox now.
Thanks. So I'd like to just briefly talk about two climate-related programs at DEQ. The first is the Plastics Pollution and Recycling Modernization Act, and thanks to Representative Helm and the legislature for passing that this last session. It really overhauls Oregon's recycling system. And one of the key pieces in it is that it requires producers, manufacturers of packaging, looking at this right here, to pay for those overhauls. And they pay for it by the amount of packaging and also the types of materials that are used in that packaging. So there is an incentive there if you're manufacturing material to do it in a manner that perhaps uses less plastic. The second program, which is currently in the draft rule phase, and Director Whitman was recently on OPB's, I think it was the Think Out Loud program talking about it, is the Climate Protection Program. And it's essentially a cap and invest program that sets emission limits for certain polluters and ramps them down. And there's also a mechanism to reinvest in areas and communities that are impacted by climate change the most. So again, those are just draft rules. It's something that the agency has undertaken based on Governor Brown's order for the agency to use its existing authority to address climate change. And the comment period was extended, and it's actually still open, October 25th, I believe. So you should get online, read the draft rules, provide comments. Yeah, so I just wanted to mention both of those programs.
You don't have to be a lawyer to comment in
Oh.
administrative proceedings.
Good point. Yes, anybody can comment on the draft rules.
One of the places that, I mean, obviously climate change was at the heart of the youth climate case. So we represented the League of Women Voters in supporting Juliana VUS, the federal youth climate case. And then we represented Ollie and Kelsey, who were suing the state of Oregon to try to address climate change. And obviously that was the heart of the issue. We never actually got to the facts because this was an instance where the courts are essentially unwilling to wade into what is viewed as a political issue, not a factual issue. And I think the post-truth era and the kind of clouding of climate change definitely played into that case, because even by the time when we got to court, the state wasn't arguing that climate change isn't a huge problem. They just didn't want to be told what to do about it. And I think the delays and the post-truth and the clouding of the issue delayed so long getting to the point where we can agree that climate change is something that is a catastrophe, that now we're like still trying to decide and agree what to do about it. And that is a place where courts see that as those are policy decisions, and it's up to the legislature to decide how to address those issues. So I think it's challenging because it's definitely a place where the law, the policy, and the science come together. And even though now maybe the state wouldn't argue that this is a catastrophe and we need to deal with it, we're still so far behind the ball on getting agreement on what changes need to happen and where to start, that I think it's played out in that instance where the courts kind of are just throwing up their hands that, well, we'll just leave it to the legislatures to decide. And of course, as Representative Helm's describing, there's a lot of delay in what can happen at the legislature. I agree with Tom that there just needs to be some rule changes that force agencies to more directly address climate change. Another place that I do work that was mentioned that Representative Helm did as well is in Oregon's land use system, which is planning and zoning. And there was a push a number of years ago to add a planning goal that would have addressed climate change. And the agency at that time said, well, we can get at climate change through the existing rules. Even though there's no rule that says you need to address climate change, there's rules that say you need to address natural hazards, and there's rules that need to address transportation, so we can address climate change through these other rules. And I just think that was such a missed opportunity because it's not happening. Those rules don't say, and you need to address climate impacts. They don't say, and you need to address equity impacts. So I think that some rule changes that really more directly tell these agencies that they have to look at what these impacts are as part of these analyses are going to be pretty important to really getting us there. In the meantime, it feels like we're kind of raising this issue over and over again, but without any teeth to actually implement it. And there have been some recent efforts just in this last session to pass bills that would have required a kind of an analysis about climate and equity. Hopefully those will move forward again. I don't know, maybe you know more why about they didn't go, but so I think there is some good momentum at the state and federal level to be looking more at climate change directly and including an equity lens to that as well. But it feels like we got to take advantage of this moment and get those policies in place and then really be able to make sure they have teeth so that then we can actually implement them and hold polluters or hold emitters accountable for those rules.
I have great faith in the agencies of our state to execute on what the legislature asks them to do, so long as we fund them adequately, and that is not always the case. In fact, DEQ has not been funded adequately, in my opinion, for a couple of decades. That represents a political decision, and it's a political battle. It's a tactic that's often used. You can leave the rules in place, but you don't provide enough funding to staff an agency adequately enough to carry the rules out. So we have to continue to support our agencies in that way. That being said, in Oregon, fighting climate change and getting to the place where we want to be as a state is not going to happen in the courts. We've already got a trajectory set. Governor Brown's executive order shortly after the 2019 session, where some of my colleagues walked out of the building rather than to vote on a climate change bill, sets the trajectory for this state for the next few biennium, I would expect. And what she's asked her agencies to do, we deserve to give those agencies some time to execute on those instructions and do their best job. They are really just getting moving. The big challenge in Oregon for the future of climate change is how we address transportation fuels, plain and simple. And That will be a combination of market forces, perhaps some agency rules, and perhaps some legislative instruction, and some encouragement to adopt new and better technology. So if we can, and that is going to be more of a social contract issue, an agreement among Oregonians about how we want to go about it, than one that is of the sort we've been talking mostly about tonight, which is command and control, federal delegation of power to the states to do something to protect people. It'll be a little bit different. And that's probably a bigger question for another forum.
Okay, thank you. So I think we are in the questions portion of our, yeah. So does anybody have a question? Right over there.
Testing. Hello, I have a question for Tom. So you spoke about the secret deliberations in agencies, and I was just wondering how that interacts with the Freedom of Information Act. The Freedom of Information Act.
Is it working? Yeah, I've unfortunately got some experience with that. Those privileges, and in particular the deliberative process privilege, applies to Freedom of Information Act requests, and agencies are increasingly able to shield documents and information and facts from public disclosure, even under FOIA.
Oh, man. That's sad.
Take the opportunity to respond to that question as well. And you know, at the state level and just at DEQ, you know, the Oregon Public Records Law is a disclosure law first, right? That's the intent. And one of the first things I heard when I started working with the agency was write every email as if it will be published in the Oregonian. And I think that at least at DEQ, we take public records incredibly seriously, and we take disclosing very seriously as well. Again, the default is disclose it. There are some exemptions that apply most commonly, and that's our attorney-client privilege when we're talking to our attorneys, which is DOJ, right? But generally speaking, we're getting, I think, much, much better with our records. And we're going through a lot of modernization with our own technology that if you haven't worked in a state agency, you might be kind of shocked. But, you know, for example, previously, most of our databases, we would have 200 whatever different databases, each program having their own database, and the legislature has funded a tech project for DEQ. It's called Your DEQ Online. It's going to put everything under a single umbrella. A lot more data is going to be publicly available. So certainly the position of DEQ is of transparency and of disclosing public records.
I just have to briefly respond. I have not done a records request to DEQ, but Oregon's law on public records is awful. It is. You have to pay. I mean, that it does not have an exemption for fees, and that's designed to keep people from getting information. And until that changes, under FOIA, you often can get fees waived, and you usually do. But when you try to get documents under Oregon's law, you have to not only pay for the documents, you have to pay for the search to find them. And for a lot of entities, that's just prohibitive, and you can't get the information.
Any more questions?
Hi, my question goes to Representative Helm. In the environmental studies major at Lewis and Clark, we talk a lot about mitigation of climate change, and then we also talk about adaptation. And I think a big fear with a lot of our undergraduate students that I've talked to is the urgency for climate change, and the kind of idea that with a lot of these hoops that we have to jump through to get things done, we might not have time to get some of this ball rolling. And so I guess my question boils down to, are there any more adaptation type conversations going on right now? And that is to say, discussions about maybe ways that we can react to climate change if we don't have time to mitigate the effects in Oregon. And I guess that makes me think a lot about the wildfires and the smoke that people were experiencing, as well as maybe the ice storm and some other kind of natural disasters that have been experienced, and the effects that, I don't know if that was clear at the end there, but that's kind of my question. Are there any any discussions going on about what we can do to kind of adapt to the future?
Yeah, well, thanks for finally asking about water. Before I get there, the answer is yes. Really, a lot of what we'll be doing in the West, I think, as we try to address climate disruption, will be adaptation and mitigation. My understanding of the science is, even if we were able to make some of the changes that we would all love, like electrifying all vehicles or turning them to an alternative fuel that doesn't create greenhouse gases, the effects are baked in until about 2040. So no matter what we do, we're going to have to deal with the decisions that we didn't make and should have 40 years ago. So yes, the answer is yes. On the wildfire side, in particular, we're giving more attention to prescribed burning and how we can return forests that are at least within Oregon's jurisdiction to a more natural regime. That is more complicated by things like insurance than I would like, but that's an example. On the waterfront, one of the things that the Climate Institute at OSU has shown us is that the water regime in Oregon is changing from one in which we stored most of our water in snowpack. That will be changing drastically over the next 20 years, in which our snowpack will largely go away. We'll get the same amount of precipitation. It'll come in rainfall. That's not horrible news, except that it will run off quickly and head to the ocean or to the Columbia faster than we want it to, both from an ecological point of view and from agriculture's point of view. So in that instance, the response has to be better planning and better ability to understand everyone's water needs and a capacity to agree to share water where we need to, and not allow old mechanisms that are enshrined in Western water law to get in the way of that. That is a huge task of mitigation and adaptation, and I'm really happy to say that we are working hard on it. I hope that you will hear more about that in the coming year, because it should become a focus of the next governor, and it certainly is a super high priority for me and my colleagues right now.
I have a question from one of our online participants. Earlier, it was mentioned that the environmental sphere needs to get better at messaging. When I think about utilizing effective messaging, it seems like one of the reasons timber oil resource corporations might be better at it is that they are able to throw more money at it. In that regard, what does getting better at effective messaging look like for environmentalists on a practical level? This is for anyone.
Yeah, that's a good question and a good point that yes, large corporations can generally throw more money at messaging than scrappy nonprofits or state agencies, perhaps. I think that's part of it. there are people who can help with the kind of strategy about where to place messages. But I think there's also probably a lot of people in this room and of your generation that have a very good sense of kind of how things go viral and how short and sweet messages can work on online platforms where maybe you can get a pretty big reach even without a huge budget. And so I think that there is part of the issue is just turning science and long peer-reviewed papers into memes. I mean, honestly, that's what it is. It's like, how can you take this peer-reviewed paper about how thinning in the backcountry does not actually help protect communities from wildfire and turn it into a meme so that people can actually understand, oh, this is why our wildfire policy should not focus on thinning in our national forests or state forests, but should focus on protecting homes and communities outward. And so that's just, I think, an example of one of the places where you can actually be quite effective with a relatively small budget if you're being smart in the way that you're communicating in a modern parlance.
Any more questions?
Hi, everyone. Janice Weiss. I'm the Environmental Law Program Director at the Law School, and thank all of you for all of your great remarks. One thing strikes me, that on many levels, we're so fortunate to be here in Oregon. We've got some relatively progressive policies and ideas and things. What are your thoughts on, other parts of the country where, we may not have the types of legislators and agency folks that we have here in Oregon, and very different scenarios play out in different parts of the country. Just any broad thoughts on, the combative atmosphere that is happening in other states, beyond our borders, and how do we, maybe to Courtney's point, how do we message, we all need to talk to people who disagree with us, right? Like we don't do enough of that. And how do we do more national discussions, outside of Oregon, if that's even possible? And Kieran, for example, do you talk to counterparts, in other state agencies that don't maybe have the same political scene or support that you might? And, just thoughts on that.
So the answer to your last question is yeah, absolutely. There's at least one organization that I participate in regularly, and it's all of the clean air regulatory agencies from around the country. And typically we'll have folks from OECA, which is EPA's enforcement office in DC, attend. And, I actually think that from a regulator's position, a lot of the challenges we face at DEQ are pretty consistent throughout the country. And some of that coordination was really helpful when the pandemic first started and we were trying to figure out, okay, well, how do we perform inspections? How do we keep our employees safe? How do we maintain this balance between our obligation to enforce the law, to protect the human health and the environment versus being mindful of the disruptions that COVID faced, that we all faced. So, I do think Oregon is great. Obviously, I've lived here since 2008 when I moved down to attend law school. But we do face some challenges, and we have some really pristine places to protect. So. Yeah, I'm not sure I really have a whole lot of insight beyond, what's going on in other states.
I don't know. Okay. Courtney just encouraged me to talk about the urban-rural divide, so-called. First of all, one thought came to mind, and we sometimes lose sight of this as Oregonians because we are so passionate about protecting our beautiful state, the air and the water and the wildlife. I certainly identify strongly with that. And when I go to national conferences with my peers in other states, and I serve on committees, nationwide committees that have to do with environmental protection and renewable energy in particular. I sit in those committees and I don't really have much to add because the rest of the country is so far behind Oregon. And they don't want to hear from me again about how we've already solved the problem and here's the Oregon way. So know that we do a darn good job in this state to protect what we have. That's not to say that we shouldn't do more and we shouldn't remain vigilant. On this issue of national politics and the disconnect between people, I think it's fueled by a strategy to make people feel like politics is broken. And it's easy to break politics. It really is. You can think of your own examples. And when everything is broken, what do? When it comes time to vote? You throw the bums out. That is simply not the case. I certainly don't believe that Oregon politics is broken. And I'm skeptical of the notion that federal politics is broken. I think we have some examples of some very outspoken individuals that say crazy things, and the media likes to tell us to look at that over and over and over for their own purposes. In Oregon, in terms of getting past this so-called urban-rural divide, it's all about relationships. And I have taken the approach that you do that one person at a time. I'll say that my own personal approach to that, since I've been in the legislature and I'm now heading into my 6th year, 4th cycle, it seems like a long time, is one person at a time. I make a special effort to understand the concerns of my Republican rural colleagues and try to work with them. And I've been successful in doing that. I have good friends who are Republicans in both the Senate and the House, and I trust them. We need more of that, and it really has to happen one person at a time, one issue at a time. And I encourage my colleagues, find an issue, any issue that you like, that you can find a commonality with a Republican or a senator or a House member. Just go work on it with them. That one thing will open up the ability to work on tougher issues if you're honest and respectful with them. And if you approach things that way, this notion of where you live in the state and local cultural values starts to evaporate, and you really realize that we're all human beings, we have the same needs, and we can respect each other's values and get some positive things done together. That's the way I approach it.
Hello? Okay. So in our society, I think oftentimes it's discouraging to go into environmental law because it's like the cases take time and sometimes you don't get the payout immediately or the outcome that you want. So my question is there ways to make systemic change without going directly into environmental law? And is there anything that you regret or wish you could change or anything you wish you knew before going into environmental law?
I can start there. I'm actually not an attorney right now. I'm not a practicing attorney for the agency. And there are many people that work for the government that have the JD, maybe they're licensed, but they're not actually doing lawyer work. So to answer part of that question, there are a lot of other policy opportunities out there where you're not actually in environmental law, but you are making systemic change, or you can make the change that way. So.
I agree with that. I think as a lawyer, you can help community members understand what is a complex legal landscape and really find a path forward to solve the environmental problems that they are trying to solve. And so one of the places where I find joy and energy is in the clients that we work with and the communities that we work with, and the times that we get to help maybe just a small community or small community members really find a path forward to find a solution. I think when you think about lawyers as problem solvers, I think that's a really self-empowering kind of place to think about it. So even though a lot of our cases take a long time and we don't always win, there's such a huge value in being able to help problem solve for community members. And I think one of the things that we're really thinking a lot about at Crag is providing those services to more groups and more communities that have not traditionally been the face of the conservation movement. So we still have a lot of clients that are the Sierra Club, groups that have been doing this work for a long time, but more and more we're providing really more like policy level support to Verde or to Opal Environmental Justice. We're working in partnership with Beyond Toxics and NAACP to find policy solutions. So having that law degree helps you to be able to help your clients and your partners navigate those legal areas. But to Kieran's point, it doesn't only look like litigating. It can also look like, what could a legal solution look like? And if we're going in to meet with Representative Helm, how can we present what we're looking for in a way that he could say, oh yeah, this looks like a law, and I think that we could try to find a path forward here. And so having a lawyer to help you be that intermediary and help navigate this system, I think is a really helpful and empowering tool to have. And I think it's when you think of yourself as just elevating the voices of the communities that are trying to protect their own environment, I think it's a really powerful tool to be able to offer.
Yeah, you definitely don't need to just be a lawyer to make systematic change. We need a lot more people like Kieran in government agencies doing really good things, and that's critical. I mean, I am a litigator, but I also am well aware that by the time something gets to the point where we're filing lawsuits, that means something hasn't worked. So I'm always mindful of that. But I did start off my ethics class this year reminding all the students, and I think it's easy to get depressed these days. I mean, our system is struggling right now, and there's a lot of things about this country that are really problematic. But one thing that this country gets right is a small organization in Central Oregon can come to me and say the government did something illegal, and if they have $400, they can file a lawsuit in federal court, and I can go in federal court and I can argue in front of a judge that what they did was illegal. And if I've got a convincing argument on the law and the facts, the judge will actually tell that agency that what they did was illegal and stop them from doing it. And there are not very many countries in the world where that's true. So I always try to remember that too.
I'll just say that I've kind of done it all now. I started out in a private firm. I did opposition work when I crossed paths with Courtney the first time. And then I worked as a government lawyer for our regional government, Metro. And then I wrapped up my law career as a hearings officer, a sort of mini judge on land use matters here around the state. When I went to the legislature, my legal background was easily put me head and shoulders above my colleagues in the ability to know what I was doing in the drafting of legislation and helping our own lawyers do what I wanted them to do. and not go through an iterative process forever, and actually collaborate with them. So anybody that's thinking, wondering how useful a law degree is, it's very useful, and it can play out well in the environmental arena. But one caution that I would give everybody is, you may not be in total control of what area of law you go into because of your personal proclivities, what you like. Just because you value environmental protection doesn't mean you're going to be happy enforcing federal statutes. That happened to me. I went to law school during the forest wars in the late 80s to protect the forests. And I got into my environmental law classes, and it just didn't light a fire for me to do practice with the federal statutes. That's why I turned to local law and land use law. It fit me better. So know what you want to get into and be open to the idea that it may not be very fun for you to do one type of law versus the other, but know that the overall training is going to be very useful at some point.
Hi, everybody. My name's Alexander Chappelle. I'm one of the student co-chairs for the symposium. Before we conclude, I'd like to invite our keynote speaker from yesterday, if he would like to add anything from anything he picked up on from the panelists. So, Naveed Mansouri, would you like to?
Oh, yes. Anyway, thank you so much. That was amazing to hear. Just like the admiration of the people who do actual work, rather than us academics, who just ask questions. I thought that, partially one of the reservations I had sitting here was that I know nothing about environmental law and policy. But I had the privilege of sitting in 2 classes today and learned a little bit about what the students are thinking. And I think in 2 occasions you heard the question. It was the last question that was addressed, or one of the last questions, but I want to sort of ask it in a more pronounced way. Because effectively, in terms of if we're thinking of trust, the students in this room are also distressed or suspicion. I would say that there are a lot of students who are also feeling that about the legal profession. And so you all who are sitting here, partially what's happening right now is you're also communicating indirectly or directly whether or not entering these kinds of official institutions are worth pursuing. And there is a lot of understandable suspicion and doubt about whether that's the route that they want to take. And so I thought, to wrap up, I would effectively play the role of the chorus. I would pose that question. So to you, addressing the students, effectively, can you make the case that in the sort of face of what is effectively the urgency of now can be no more literal than climate change. And so I think that, especially on this campus, one of the places that students might look is something like Standing Rock, right? You have Standing Rock, and then you have legal reform. One person might think that those are 2 diametrically opposed phenomena. Another way you might think of them, that there's a mimetic relationship. So you might think, for example, of centuries of struggle that result in something like the Civil Rights Act and the enforcement of those things. So certain kinds of political truths that were fought for become codified. It's not necessarily value neutral. In fact, it's incredibly value laden, but ones that I don't think we would be mad about. These are progressive policies based on human-made values that are, we could call them ideological. And so So I would just want to pose that question, and this is me trying to articulate it based on what I heard today from a first-year classroom and a fourth-year classroom, and to pose that question to the panelists. How do you think of the relationship between those extrajudicial acts and the work that you do, and how would you communicate the worth of entering these spaces, provided that there might be a sensibility that the real work is being done on the ground?
Thank you.
We always think of our work as one of the tools to achieve change. And so one, I think, really good example to talk about is the fight against the Nestle plant in the Gorge. That was a proposed water bottling plant, would have created millions of plastic water bottles from these pristine springs out in Cascade Locks, would have fundamentally changed the feeling of that national scenic area. And that was a fight that took all the tools. It took activists marching. It took a Native American woman doing a hunger strike. It took going to the state agencies to provide testimony. It took a letter writing campaign to the governor's office. It took legal challenges that in that case were kind of holding the line and sending a part of sending that message that this was unacceptable. In the end, it took changing the law. It took developing a ballot measure to make it illegal to commercially bottle and transport water out of the Hood River County. And then it took defending that new law, which was also, so there were multiple legal tools that were part of that successful fight, but were entirely part of this much bigger picture that took all of these angles. And so to you, I would say, if this is floating your boat to do policy or to do law, go do it, and it's gonna be a really powerful tool. But if you are more the get the people in the room together, if you are more the turn this paper into a meme and get the message out, then follow that. We need creators, we need organizers, we need activists, we need lawyers. We gotta do this together to make the social change happen that we wanna see.
All right, so I'd like to thank our wonderful panelists for an informative and interesting discussion as we try to further understand the post-truth environment. So let's give them a round of applause. So this concludes our symposium events for today. I'd like to invite everybody to tomorrow's events, mainly the Crossing Party Lines workshop, in which we will be learning about how to discuss science in a respectful and productive manner. That'll be taking place at 5:30 tomorrow in STAM West. And there's also a link to it on the symposium webpage. So thank you, everybody, and have a good evening.